New York today, if a 17-year-old is stopped by the police and is found to have a cigarette in his or her pocket or a bottle of beer in his or her backpack, what's going to happen?
No, not a marijuana cigarette, I'm saying. Nothing.
Right, a tobacco cigarette,
Nothing's
yes.
going to happen.
Or a bottle of beer,
Nothing's going to happen.
yeah,
No arrest will be made.
yeah. Even though both of those products are, I think, in their, potential consequences, much worse. And I don't know for sure whether possession is illegal, but certainly it's illegal to sell a cigarette or a bottle of beer to a 17-year-old. But and the public at large very much doesn't want 17-year-olds to have bottles of beer or cigarettes. And yet the consequence of a kid being found with either of those products is zero.
Correct.
The legal consequences. Yeah.
Correct.
If the public possession offense were eliminated so that openly displaying in a public place a joint was treated as the violation level offense that mere possession of that joint would be, what real world difference would that make?
I would say there is still significant issues. So number one, like desk appearance tickets or a summons ticket has significant consequences as well. There's a large number, as you know, of outstanding summons warrants. And if you have one summons warrant, whether it be for violation, possession of marijuana, open container, being in a park after dark, and you're arrested again, you're then brought through criminal court. And so you have that issue, first of all. You're putting people on, you're widening the net, putting them on the radar of the NYPD, enabling the NYPD later to arrest you. That charge still comes with fines that my clients cannot pay. Number three, you still have the problem that I talked about before. The simple prohibition itself would still allow the NYPD to use the suspicion of, or the observation of that violation to approach, stop, and frisk. So just the outlawing of itself, whether it's a violation or a crime, would still drive broken windows policing. That's my perspective.
I would add that it would take a step in taking away the reason that police action is prompted, but it will not change the manner in which policing takes place. I believe we'll still find ourselves in a situation where it will be the same neighborhoods that are under attack. It will be the same communities that are getting the violation.
Remind me of the Fourth Amendment law on this point. Is reasonable suspicion of a violation, as distinct from a crime, grounds for stop and frisk?
It's grounds for further inquiry. So it can raise the justification from a simple investigatory questioning to a common law right of inquiry, which then can raise common law right of inquiry if there's additional information that the police claims to have seen or heard or interactions to rise the level of reasonable suspicion. So, reasonable suspicion or observation of a violation can certainly lead to stop and frisk. And we see that all the time with crossing the street against the light. We see that all the time with open container of alcohol. Yeah. These violations lead to unlawful Fourth Amendment conduct.
And does making a violation arrest give an officer the same points on his or her success record as a misdemeanor arrest. And by the way, in case anyone's curious, I'm not suggesting that there is a point system and records of how many points an officer has, but an officer, I assume, somebody keeps count of how many misdemeanor and felony arrests they make. Does a violation arrest have the same significance in an officer's record? And is the overtime bonus for I mean, you know, if you make a misdemeanor arrest, you get to spend, you know, collect a lot of overtime hanging out in court instead of on the street. Is that the same for a violation, for a bare violation marijuana arrest?
I just want to add a little bit to the question you asked previously, to add to what my colleague said. And what remains of the Fourth Amendment, that is true. But we saw that with stop and frisk being ruled unconstitutional, that it is as if the law does not apply to certain people in the NYPD.
Yeah.
And so, to your question right now, that police action still allows the officer to account for overtime. And overtime is a bonus, I don't know, for many people.
Yeah.
Many people see that as a great incentive and reward to stick around in your 8-hour shift to a 12, 16-hour shift. And if that overtime money is accounted on this violation, then I'm going to look for these violations.
Okay. Questions? Crystal?
Yes, I want to thank you, gentlemen, for coming and sharing your testimony. I just want to, have you all had an opportunity to take a look in detail at the legislation?
At the start,
3506, yes, the legalization of marijuana.
to
Do
some,
you have some recommendations you think should be added to it?
I can get back to you with more information on that.
I would
I know our
appreciate if you
policy
would do
team has
that.
been thinking about that.
Okay.
But
I'll
we
give you
are
a
in
card.
support
You
of
can
it.
pass it on. Thank you.
I will do the same.
Okay.
Linda had that?
Mr. Posada, so your personal experience happened, when you were 17. So in the time between then and today, it sounds like you're describing that the exact same process happens with kids who are now 17 and have your kind of profile.
Correct.
I mean, it's disturbing on numerous fronts, but policy has changed, and rhetoric has changed around arresting people. What do you think is actually going on? Even though people say, you know, we're not going to go after people for possession, yet you say it continues just as it has some decades ago.
So, I wasn't in a suit when I was 17, so that might have been different in terms of my appearance.
Right.
But
I mean, you think people who were in your same situation today, 17, not in a suit, hanging out, they have the same chances of being arrested as you did at that time?
absolutely. I mean, the numbers that I just shared from the people that Legal Aid Society represented on this charge, the majority are between the ages of 16 to 25. And if I just take a step away from the data and just share from my own experience in the work as a supervisor in the Community Justice Unit, which takes me through every neighborhood that is underserved, that is predominantly of people of color in New York City, that is living in marginalized conditions, I hear day in and day out from Black and Latino, Latinx New Yorkers that this is a charge, that this is an issue that they are still dealing with consistently on a day-to-day basis.
And what I can add to that is, you know, the reason why there's really no difference is that they're the same there's the same incentives and there's the same insulation, right? The incentives are still there for NYPD because as long as a crime is on the books, not only can they use it as pretext, but they can make that arrest. And on top of making that arrest, they know it's going to be a successful arrest, which means an arrest to prosecution within 24 hours. Once that case either ends with an ACD or disorderly conduct and with time served or misdemeanor conviction, that not only, as Mr. Posada mentioned, closes off the public defender's opportunity to have the chance to cross-examine that officer about their illegal conduct, but it also erects legal barriers to any kind of federal civil rights suit. It admits that there was probable cause, and so any claim for false arrest or malicious prosecution goes out the window. And so when you have the incentives, these easy, low-hanging fruit for the police to go and capture folks, rifle them through the system and they're out and have no disincentive for doing so. They know they're never going to be questioned. I have never once, despite all these hundreds of cases, have once cross-examined an officer about solely a marijuana arrest. I've cross-examined officers about marijuana arrests as pretext for other things. But that means the system continues, and it will until it's legalized.
Okay, thank you. I mean, I see how deeply it still affects you, and I'm glad that you could channel your experience into becoming a legal aid attorney and helping other people through what you experienced. So thank you.
Thank you.
So, thank you for your testimony today. I just want to make sure that I'm clear on this concept of the ACD. So, it's your testimony that the ramifications or of taking this as ACD is detrimental to the person who takes it, whether it was college, applications, housing, and what were some of the other?
Immigration,
family law.
Okay. In some instances.
Frankly, any kind of consequence that could come from an arrest and a charge, because what it is it's an open charge, open criminal charge.
And how many cases would you say that they had? Let's say, and I see here you're from Brooklyn. Let's just say in Brooklyn, how many of these marijuana arrests were actually, went through the criminal justice system to court?
Trying to look for this. I'm getting there. Okay. So in 2016, 4,326 cases, so arrests came through Brooklyn Criminal Court.
And how many of those cases would you say roughly ended in an ACD?
I can tell you exactly. 2,733. So more than half.
2,733.
The majority
How
of
many of
dispositions.
those individuals were represented by an attorney, you would imagine?
Everyone.
Everyone?
Yes.
I would imagine that most of those attorneys would have come from which offices?
So in Brooklyn, there are two primary service providers, Legal Aid Society and Brooklyn Defender Services. In the Bronx, Legal Aid Society and Bronx Defenders. And there's an alternative provider and there's Legal Aid Society. And then some cases are taken by 18B. So we roughly split
Almost all of them.
Almost all of them.
So just so I'm clear at what you're saying today, that the ACDs is just as detrimental in this process as everything else is. And most of the ACDs are coming from your clients. So what role does your office play in this whole concept? And is there anything that you could do from your perspective in order to say, I don't think you should take an ACD in this circumstance because it could block you from other civil rights actions that you may have, or it may block you from A, B, C, D, E, F, G.
So the
Wanna
penal
take
law
this first?
has two sections for adjournments and contemplation of dismissal, to be completely clear. 170.55, 170.56. I'm specifically referring to the marijuana ACD section, not the other ACD.